Hey, Samok.
How are you? How are
Uh,
you? Hope you're safe.
I'm been safe too.
Glad to hear that. Greetings to all our viewers. I'm Sumuk Biram, the host of Nyayata podcast. And today with us, we have Sebin Sebastian, my dear friend and classmate. He's also an avid constitutional legal theorist. And today we'll be delving into a very rather serious subject, which is based mainly on law. So we'll be dealing with separation of powers. Before we begin, I hope all our viewers are safe and sound. Please wear your mask and socially distance yourself. To begin with, Sebin, I think to top off our subject, which is separation of powers, and in light of the current COVID scenario, I think the famous quote, I think it's everlasting. It's basically that power corrupts, but absolute power corrupts absolutely. So I think that's an easy way to sum up separation of powers. What are your thoughts?
It's an interesting thought, and on similar lines, I had a similar quote. Since we are talking about separation of powers, especially with relation to the Indian judiciary, I had a separate quote from the case Ranveer Singh versus Union of India, where the Supreme Court said, in this regard, the courts of India possess a power not known to English courts. The range of judicial review recognized in the superior judiciary of India is perhaps the widest and the most extensive known to the world of law. So, right from this outside, it's pretty clear that the powers of the Indian judiciary is not one that is constitutionally similar to that of many other countries, maybe that of the United States, the constitution of South Africa, Brazil, or Germany, for that matter. And we have a very interesting footing to even begin on with specific relation to this topic, where we see a very sui generis model, if one may say, under the Indian Constitution, where the Supreme Court almost has a very intrinsic part in the governance model under the Indian Constitution.
Yeah, I think we took majority of our characteristics of the constitution from the Westminster system, and I think the separation of powers, I think it's followed very rigidly when it comes to the United States of America. Obviously, we'll be dealing with that a bit later, but to begin with, when it comes to separation of powers, I think Montesquieu has, elaborated beautifully in his books, which is The Spirit of Laws. I think it was in the mid 18th century. But anyway, when it comes to separation of powers, I think there are three main things: that one actor of a state cannot, interfere with others' action, cannot exercise actions on behalf of another organ, nor can take the place of another organ. So are these three very similar, or are they fundamentally different when it comes to separation of powers? Because there's usually confusion on how different agents of the state should function. Should they respect each other's bounds, or should they consider that each organ of the state should act unilaterally and have no responsibility at all when it comes to whatever the actions happen?
Yes. So the interesting question that you pose here, and it has some sort of tie with the topic that we have to discuss later, which is with respect to the United States model and the Westminster model. So I'll take some references from there. Yeah. So when we talk about the Indian model in particular, we see that it's not merely a model of passive observance, it's something that comes about in almost every single discussion ever. You read this in articles, you hear this in other podcasts, you hear it elsewhere, that the role of the Supreme Court, or that of a constitutional court, also including the High Court, is not of passive observance, but it's also of fundamentally inclusive governance. So this inclusive governance happens in the forms of checks and balances. So and it's quite vividly seen in the Indian model that these checks and balances are of far more powerful nature than the US model or the Westminster model. So the US model just goes into a very strict interpretation of what Montesquieu means, and they go into this whole separation of powers with respect to the executive being very far away from the legislature, and the legislature and executive again being very kept aside from the judiciary, except in certain cases where, of course, the judiciary steps in cases where they need to judicially review a statute. Otherwise, it's always been kept off bonds. Then we come a little closer towards the Westminster model, which is where we see the British system. And in the British system, we see that the executive comes a little bit more closer to the legislature, and until recently, the the court in its the supremacy of the parliament is something that is always maintained in the Westminster system. Here, of course, in the Indian system, supremacy is given to the constitution, and therefore there's some sort of a spread in terms of the authority that is given under the constitution to the parliament and the Supreme Court, or other constitutional courts for that matter, like the high courts.
But Sebin, like when it comes to like say, I think it's pretty much agreed upon, like say in all the like say legal principles followed across the world in different countries, is that independence of judiciary is paramount. Like say no legislature has like say the despotic power to overturn the judiciary's like say orders at their whims and fancies. The only power like say the legislature has over the judiciary is maybe until like say appointment of the judges or like say resignation of the judges. But when you talk about like say the concepts of checks and balances, like how should it be followed? Like what constitutes checks and balances, what's necessary, what's prohibited, and etc.
Yes, so there are checks and balances, and so what are these checks and balances? Maybe some of them go a step further, especially when it comes to the judiciary, in terms of when you compare it to the other models across the globe. And what are the checks and balances in the hands of the executive? We have executive and the legislature when compared to the judiciary. They are making sure that there is no corruption within the judiciary, that the impeachment of judges, so on and so forth, falls within the hands of the executive and the legislature. On the other hand, what are these checks and balances that fall within the ambit of the judiciary? Then we see a whole set of tools such as judicial review, which has been of course been used widely in various circumstances to make sure that the parliament does not digress its powers, and it basically does not create an action that is ultra vires the constitution. So these are checks and balances that the parliament has, i.e. the executive and the legislature, and on the other hand, where the Supreme Court has.
I think it was like say pretty much sufficed in like say in the Banke Singh case, where it was like say clearly told that the parliament or legislature neither explicitly nor was it ever intended by the constitutional framers that they can overturn any aspect of the judiciary or the judicial decision. I think that was the prima facie importance was given to say the independence of judiciary. But when it came to like say other after the judiciary and jurisprudence evolved when it comes to constitutional cases, in the case of Ram Jawai Kapoor, they said that we don't follow the separation of powers, which is as strict like the US, which you mentioned already, like how the Westminster system is different. But at the same time, they said that our concept is more likely, which is based on separation of functions, but not separation of powers. What
the Supreme Court in general has some sort of a checks and balances function far more superior to the others, especially with the relation to its PIL functions and or its Article 32 powers. So I don't think I can quite elaborately put out the powers of the Supreme Court unless we really go into what the PIL is and how it came about, and the powers of the Supreme Court with respect to Article 142 and Article 32. So in Article 32, there is an interesting wording that says, which allows the which basically allows the Supreme Court to pass such orders or writs that may be appropriate to fulfill the ends of the fundamental rights. And this word, which was termed appropriate, was actually construed quite widely in order to introduce the system of PILs, which we now know as the system of PILs, which is now basically stood as a bastion of fundamental rights. And this is the form of an enhanced checks and balances which you see in India, which is not particularly prevalent in any other system. That's something that really holds the Indian system far more uniquely than the other systems.
Sebin, to our viewers, like say, who are not well versed in like say the legal and how like say how law works. So I mean, we have all heard that like say separation of powers cannot be amended. It's intrinsic and it forms of some concept called as basic structure. So can you like say explain or elaborate when it comes to what basic structure actually is?
Yeah, sure. So the basic structure, while not a unanimously construed topic under the Kesavananda Bharati decision, it was still the majority decision. So what the basic structure essentially is something somewhat of a topic, to be very honest, that the judiciary itself has been juggling with. And it essentially, in my own words, I would like to say, basic structure is basically what the constitution fundamentally is. So it's something that the essence of which, or in the absence of which, the constitution of India would effectively cease to exist. Okay. So when it comes to this, so what the Supreme Court did in the case of Kesavananda Bharati, they went about certain doctrines, and they said, look, there are certain powers of amendment that are given to the Parliament. However, the Parliament is a creature of the Constitution. This is to quote Nani Palkiwala himself. Palkiwala says, the Parliament is a creature of the Constitution, and a creature of the Constitution cannot itself destroy the creator. So here the creator is the Constitution. So the Parliament's amending powers fall only within such extent that it does not defile the Constitution itself. So when they theoretically conceived such a concept, they stated what would possibly constitute these ideals or frame or that basic framework that we now call the basic structure. So they laid out certain basic features, such as the federal system, the secular system. So, and one of the important facets that they underlined was the separation of powers between the executive, legislature, and the judiciary, and which is an intrinsic feature of the Indian Constitution. I.e., no law that is passed by Parliament, or I mean any amendment that is passed by Parliament, insofar as it goes ahead to distort this line of separation of powers between the executive and the judiciary, it can be held as it'll be held as unconstitutional. With this was prominently seen in the NJAC case, where they struck down the NJAC amendment by saying that to ensure the supremacy of the Constitution inherently, it is important that there is a separation of powers between the executive, legislature, and the judiciary. Therefore, it is inherently important that judges form a pivotal part of the judges' appointment function, etc. So they held that this particular law was unconstitutional, and this amendment was unconstitutional, and was in fact of the basic structure. Yes.
To sum it up, to put it up very briefly, what you're trying to say is that if we consider, like, say, the Constitution to be a human body, what the basic structure actually is like, say, it's the skeleton which gives the body its shape. So if there's no skeleton, it's as good as a body of flesh. So you're saying that without the skeletal system, there's nothing which might materialize into the Indian Constitution.
Yes, that's exactly what I'm saying. That's basically the structure that we see with respect to the Constitution itself.
Yeah. So, Sebin, like, as we have discussed, like, say, extensively on what the checks and balances mechanism is. So when it comes to, like, say, COVID-19, obviously everyone is facing like a grave scenario, and we are, like, say, in a privileged position to talk about, or say, at least, like, say, frame policy when it comes to how things should work. But the majority of the people who live in the rural areas, or say below the neo middle class line, are facing extensive, like, say, deaths, or like, say, even access to justice is not provided. They don't have food, they don't have medicines. And obviously, like, say, we need to consider that the authorities, along with, like, say, the legal aid and NGO civil society members, are also trying to give their best to give their best to society, but it's not, like, say, to the extent which is expected. So in these times, so what exactly is the court supposed to do? So when they say we are the keeper of public conscience, and that is what one of the fundamental duties of the court, how is keeper of a public conscience different from, like, say, checks and balances, or are they?
Okay, this brings us back to a very interesting debate, and I don't think, again, we can fundamentally go ahead with this topic without discussing something known as the differentiating between justiciable rights and non-justiciable rights. So justiciable rights fall, for example, like the fundamental rights, and can be enforced at any given point in time. However, on the other hand, we have certain socioeconomic rights that come under the DPSP, which are non-justiciable. That is, you cannot legally sue or file a petition to enforce these particular rights which are given to you. So, but then there have been instances where there have been blurred lines within legal interpretation in India, where certain socioeconomic rights that would ideally fall under the domain of DPSP have been brought into the domain of fulfilling fundamental rights. So that I feel that forms an important part of this debate of around COVID-19, because what we see is the Supreme Court over a certain number of years basically formulating that to fulfill the needs and necessities under the fundamental rights, it's also important to fulfill certain socioeconomic rights. And therefore, they've read into into Article 21 various aspects that have not very explicitly been written there. It's not something that only legal students know this. But anyone who takes a bare reading of the Constitution would see that right to health is not something that's mentioned explicitly in Article 21. Or I guess we can keep the debate very specific to the right to health, foodstuffs, and basic living conditions. Okay, and the basic living conditions or foodstuffs are not something that's been read into the Constitution. But however, very interestingly, we still see the Supreme Court passing, or Supreme Court or the High Courts passing orders or continuing emphasis in ensuring that these needs are fulfilled. And I guess that leads us to another fundamental topic of how socioeconomic rights have been dealt with, particularly around the world. So I guess again, so there's
before we go for in the Supreme Court, I think it was passed, I think in early May, I think it was 2nd May or something. So this was with respect to the distribution of essential supplies, and essential supplies include oxygen and all the things which we're talking about, right to health and right. Can you give us a brief background of this case and how it exhibits the true nature of Indian judiciary?
Okay, so the suo motu powers being a very huge matter of question by themselves have been debated right through the pandemic. There have been hues and cries about how the Supreme Court, again, this is the same passive, not a passive watcher of activities, but hence they're actually really an active part of governance. And all these topics have come in front, and a lot of people have requested the Supreme Court at many instances, right from when the pandemic began in 2020, to take suo motu cognizance of multiple activities. And then I feel that it came a bit late in terms of the judicial action that was taken, but nevertheless, in light of the oxygen supply, and I guess especially with the second wave hitting so hard, the judiciary decided that it needs to take suo motu cognizance, especially with respect under its powers given under Article 32 to ensure that certain fundamental rights are fulfilled with respect to the Indian citizen. So it's this particular case itself is it goes ahead and it talks about only certain fundamental points, which is 1, the supply of oxygen; 2, the supply of essential drugs; 3, method and manner of vaccination; and 4, the power to declare lockdown. So they've gone only towards those topics, which fall under the area of socioeconomic rights. But still very fundamentally concern themselves with the minimum core of a fundamental right as well. So,
but is it akin to creating new policy, or is it akin to supervising? Are they just saying that your government has certain plans in mind? Obviously, if you know, there are the Disaster Management Act provides under one of its provisions to create a national plan, and this has been into effect for over a year now, because when it was first enforced in early March of 2020, they have been following a certain national plan, and they're giving revised orders or circulation. All these orders include basically your normal lockdown circulations or vaccine circulation and etc. So are they just saying that there's this plan created, I'm just going to supervise this, or are they the government is not doing enough, but I as a organ or institution of the country or the constitution, I am obliged to create certain policies? So what is it?
I would believe that the latter is particularly true in this case, where it's not merely obliging to formulate certain policies. It's recommending various steps in terms of making sure that certain fundamental rights needs are met. So I would actually pose a counter question. So could you say that it would be a digression, or like it's somewhat unusual to see this in the that the Supreme Court stepping in and taking policy decisions.
Yeah.
Like in yeah.
Like obviously
So-
we'll have to, everyone has like say a dual approach to this. Like say when you're talking, when as a like a common citizen and etc., you would expect like say all sorts of help, because like say these are like say institutions of people who can make a difference, and it wouldn't hurt like say for people to actually show spine and tell that, look, this is where you're lacking, and therefore we're asking you to do these steps, because ultimately whatever process which they're following is ultimately for like the benefit of citizens and helping saving lives. But on the other hand, when it comes to like say creating new policy, one thing which I as a law student would be wary about is it doesn't become a tendency, in the sense that obviously now we are in an exigency situation, and therefore every civil actor or like say institution has to come into play. But what if tomorrow they believe that, okay, this government is actually incompetent, not only this government, like any elected government, whether it comes to high courts and state governments also, if they believe that they're lacking in this particular aspect, I will definitely take steps to ensure that they fulfill these actions. Obviously when it comes to like say mandamus actions, it's meant for like say enforcing them, to say that, okay, if you've been deprived of like say a right to health, they'll ask you to pass a like say writ of mandamus to tell the authority to do certain needful tasks. But I feel that if the suo motu petitions like say increase on a drastic basis, I think it would have a problem. So what are your thoughts on it?
Exactly. So the answer that you've presented is particularly, because it's a sort of a system that we see very sui generis in India, which we don't particularly see in other constitutional setups. Okay, and to highlight the difference, I would actually bring in the example of both Germany and South Africa. So in India, socioeconomic rights are for the DPSPs and are not essentially justiciable, except in cases where the Supreme Court has gone ahead and read them into the fundamental rights, especially into Article 21, etc. So, but nevertheless, the Supreme Court has gone ahead and enforced various actions by stating that, hey, look, these amenities are not fulfilled. We would like you to take steps. We would like you to take actions in order to make sure that these acts are fulfilled. See this especially in the case of the in environmental cases and mostly initiated by MC Mehta. It's something that's very commonly seen. But however, when we move to the South African model, socioeconomic rights, unlike the Indian system, are actually even justiciable, where the framers of the South African Constitution went ahead and they made sure that there are provisions for ample right to health provisions, ample provisions for good conditions for living, and all of this, with all of this still existing, when the question of whether enforceability of this rights came into question before the Constitutional Court of South Africa in a particular case, and this is one of these landmark cases where the South African Constitutional Court there was a question which was raised in terms of amicable living conditions, and in this particular case, one of these petitioners came and he said, look, I don't have enough ample living with the courts to enforce my fundamental rights and therefore make sure that I receive ample living conditions. However, the Constitutional Court of South Africa did not pursue that. It in fact stated that it in fact laid down a different test where they set out a reasonableness standard for an existing policy of the government, where they saw if the existing policy of the government was covered all sectors, that is the sectors where this particular petitioner lived and all of that, and to make sure that it served all categories of the society, and to make sure that these ideals set forth by the Constitution are fulfilled. And they saw that one of the existing policies in terms of ensuring ample living conditions did not meet the reasonable test, and they struck it down as unconstitutional. But however, what they did not do was they did not particularly go ahead and state that in favor of this particular petitioner and state that, hey, look, the executive must fulfill its role of since this particular right is justiciable, and go ahead and make sure that he has ample living conditions, because they felt that it would be digression of the separation of powers. So So when we come back to the Indian model, even though the socioeconomic rights have not been justiciable, there have been instances where the Supreme Court has gone ahead and created models or policies to make sure that certain steps are taken in various sectors in terms of health, foodstuffs, and in terms of amicable living conditions. And and I would say this would be a problem that would deeply run into the accountability of the legislature and the executive, and also with respect to how even elections are even conducted. So are we meant to know how exactly is a common man? Sometimes people who are not aware that it has actually been the judiciary who has taken these steps, supposed to know whether these are steps that are taken. They know it's the government is blurred, and it becomes a problem, and it might even.
So I think this puts a fundamental question. Like, say, before we conclude, we need to talk about the Karnataka High Court's different approach. So, like, I think it's like, say, the Roman theory of how democracies worked, because the Romans also had senates at certain points of time, and when, like, say, their enemies were at their gates and etc., they used to elect amongst themselves a particular dictator who kept the public conscience, like, say, in his mind, and then used to take actions in order to win the war. So I think the judiciary here is trying to say that, look, no matter what happens, we are the only one who's neutral, because see, no matter what we say about the legislature and etc., it ultimately consists of, like, say, political parties who have, like, their ideological leanings and etc. So if we look at it from, like, say, prima facie or a neutral point of view, it's only the judiciary which has no color attributed towards it. But what do you, like, say, this is a different approach taken by the Karnataka High Court. This was also, like, say, passed by the High Court a couple of days ago. It was with relating to foodstuffs, and, like, obviously everyone knows there's a lockdown in Karnataka right now, and many people are suffering due to lack of food. So they basically said that I'm here to safeguard socioeconomic principles and etc., but I'm not going to create policy, in the sense that there was already a policy which was meant for distributing food grains for free or, like, at a cheaper prices at Indra canteens, which was done by the previous government, and it wasn't continued with the present government for obvious reasons. So they said that you already have a policy, why don't you take this and give food to the poor? And, like, the Karnataka government has obliged to it. Now, whether that will come into force, and I hope it does, because there are many people's lives at stake. So what do you think of this approach? Is this the better approach, because they're not creating policy, but rather saying that, okay, dude, you already put your words over here by creating this
Yeah, so primarily Karnataka High Court does make an effective stand with respect to these matters, where it is making sure that the previous precedents where socioeconomic rights have been read into the fundamental rights regime are being enforced. But at the same time, they're not digressing into the role of the executive or the legislature by stating that these are the particular steps to be taken. And I would actually try to take an obvious polar opposite of this particular case, where there's this one case in called the Deepak Rana versus State of Uttarakhand, where the High Court of Uttarakhand took judicial notice of various schools, and they went ahead and they stated that, oh, look, these schools are in very terrible conditions, and we will be making sure that none of these state government officials will be getting luxury facilities until these schools get their basic amenities, so on and so forth, which was basically policy decisions. Which was not based on anything at all. So there was no basis or statute upon which these actions could have been taken. Nevertheless, simply on the understanding of Article 21A, these actions were taken. The High Court of Uttarakhand said that in order to fulfill the ends of Article 21A, we need to fulfill all these things, and therefore basically is not something that has been followed by the government, High Court of Karnataka. Far more, and it has been taken in certain aspects, I would say, but nevertheless not to the same extent as it has been taken in the So the Supreme Karnataka High Court goes ahead and they state that, hey, look, there's an existing policy. This is not a policy that we're formulating. We're not deciding where the funds go. We are just stating that in order to fulfill fundamental rights of citizens, it is essential that you go ahead with these. You go ahead and make sure policy reaches out to the sectors of public, and the ends of Article 21 and Article 14 are met. So I think that's a very it's constitutionally the most sane and safe method that could be followed, which was taken by the Karnataka High Court, I would say.
Yeah. So yeah, I think that pretty much sums up